So while we have been talking about the DPDP Act and the grievance redressal system, let's talk about the topmost stage of the grievance redressal system, the escalation mechanism. Welcome to my YouTube channel where you daily see new content on data privacy. And as I mentioned, today we are going to talk about the escalation mechanism under the DPDP Act and talk about the Appellate Tribunal formed to take care of the disputes under DPDP Act. So what is the importance of judicial system? Some grievances are likely to get escalated. What kind of grievances are likely to get escalated? Principals are not satisfied with the kind of decision taken. They were expecting a different decision. They think their rights have not been honored well. There is too much penalty on the fiduciary. Fiduciary is not satisfied. Fiduciary has some reasonable cause, technology issue or understanding issue or something. Similarly, principal could have a understanding issue and they are not satisfied with the decision that the board has taken. So board can, the principal or the fiduciary can move ahead in the escalation matrix. The Act says any person aggrieved by an order or a direction made by the Data Protection Board under the Act can move on to the next level, which is the Appellate Tribunal formed under the Section 14 of TRI Act 1997 to help address the disputes caused by the decision of the Data Protection Board. Escalation mechanism: you need to file an appeal with the Appellate Tribunal within 60 days of the order passed by the Data Protection Board. Tribunal may accept an appeal if it is beyond 60 days if required, provided you are able to establish a sufficient reason why you could not file the appeal within the specified time limit. Tribunal needs to listen to both the parties. They have to allow both of them to present, give them a hearing, and then take a decision. They may say that the board decision is okay and we are finalizing the same, or they may change it, or they may cancel it and create a fresh decision altogether. That depends upon the hearing and the presentations made by both the parties. The Appellate Tribunal has to give both of them the opportunity for the same. Order of the Appellate Tribunal is executed as a decree of the civil court, right? So it is the Appellate Tribunal is as good as a civil court in India. What is the role of Appellate Tribunal? They have to validate your complaint. They have to review the board's decision. They have to validate along with all the documents and evidences that you have given. They need to review the legal aspect of the decision as well as the legal aspect of the offence made so that they take a proper decision and set up precedents for data protection cases. Remember that at this stage, data protection laws are evolving. So the tribunal and other people who have to, including the board who have to take decisions, they would be setting precedents for the future cases to come in. They in any case need to make sure that they are very, very fair and transparent in handling the disputes. The potential impact of the overall Appellate Tribunal is for a data principal. There are common things for fiduciaries as well. There is a cost of recourse. There is a fee to be paid for anyone who goes to the Appellate Tribunal. There is time and effort required. Appellate Tribunal says we will resolve it in 6 months, but it may get extended, right? And then what are you expecting as a final decision? You need to check about it. And if it fails, can you move ahead? Would you actually go to a higher court? So you need to weigh both as a principal as well as a fiduciary that there would be a time consumption, there would be fee. Time consumption and tribunal fee is one thing. The fees for representing someone would represent you, the time and effort required to handle all these things which can impact the other things in your life. So how much of time and devotion are you willing to make, and what kind of result are you expecting at the end of it that you want to go ahead and fight a case or file a case in the Appellate Tribunal. The challenges of the overall process, as I mentioned, there is a cost and time implication for all the stakeholders. So all three would always get involved: the fiduciary, the principal, and the board. There could be some cases where the fiduciary is filing only against the board. Principal may or may not be fully involved, but then because in the cases where the principal went to the board and then fiduciary is not happy with the decision, then the principal may get involved. There is a lack of awareness among principals about their own data subject rights, and they might end up wasting a lot of cost in getting no good consequences in their favor. Same would happen with fiduciaries also if they are not also very well equipped with proper evidences. Decision is made on evolving laws, so you need to be very, very careful on that aspect. and the delays could also be caused because of the overburdened systems. We are all evolving. Our courts in any case are very busy, but we are also evolving in the data privacy laws, and therefore if in case the appellate tribunal is overburdened, it would take a bit more time for the resolution to come in. So you need to be prepared with time, effort, and the possibility of what level of judgment comes in your favor. So that's about the basic escalation mechanism and the basic role of appellate tribunal. In the next 2 days, we are going to cover more details about the appellate tribunal. So please stay tuned and subscribe to my YouTube channel. Share your feedback in the comment section and press bell and the like icon. Thank you.